Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Hello, everybody. Today we got Bruce Broillet here. And Bruce and I haven't known each other very long, although when I moved to California about 12 years ago, his is a name that came up on a regular basis of who the great ones were. And so I'm really stoked that I got to meet him recently and get to know him a bit better. And he's going to be coming to Trial Lawyers University in Huntington Beach to start to debut his what are you going to call it? Your TLU career, the one in person. So thanks for joining us here today, Bruce.
Pleasure.
Thanks for joining us. So Bruce, you've been a lawyer. I know you just had your 50-year reunion. Is that right? From law school?
Yes, correct.
So
yeah,
I'm guessing
I graduated in 1974.
So you just celebrated 50 years of being a lawyer.
Yeah.
Wow.
I actually started practicing in 1975. I took the bar in Texas in 74 right out of law school and passed the bar there, but decided I wanted to come to California. So I came and did the February bar here and passed it there. So I started practicing in the summer of 1975.
All right. Well, let's back up a little bit. When did you first really recognize that you wanted to be a lawyer?
I would say probably right around my freshman year of freshman year of high school. Excuse me. I was very active in speech and debate, and when I won my first speech contest, there was actually an article about it in the El Paso Times, my hometown. And my mom, is really good about saving all of the clippings from when I was young and over the years. And so years later, she presented me with a scrapbook, and I saw that article. And at the end of the article, it says, after high school, Bruce plans to go to college at Notre Dame and then go to law school. And I couldn't believe it when I read it because I was obviously thinking about this back when I was 14 years old.
And did you, in fact, get to Notre Dame?
Yes, I went to undergraduate at Notre Dame and then law school at the University of Texas.
All right. And when, as far as law school, and that's where you're from, is Texas. So how did you, decide to make the move to LA?
I had grown up in El Paso. I had gone to college in South Bend. I'd gone to law school in Austin, which at the time was a fairly small town. And I wanted to see what it would be like to try to do this in a big city. So I considered New York, Washington, D.C., and Los Angeles. Came out to visit a good friend in Los Angeles right after the Texas bar and before I took the California bar, and just loved it. Loved LA, loved the energy, loved the weather, loved the optimism and the future. And so I decided to come to LA and do it here.
Yeah, I can understand why. When I first saw LA about 13 years ago, when I came out, because I was friends with Nick Raleigh from the Trial Lawyers College, and he invited me out to come and help him on a case. And when I saw LA and the weather and just the vibrant legal community and just the camaraderie amongst plaintiffs lawyers, we didn't really have that. I never saw, if it existed back in Michigan, I never noticed it, but I noticed it more in California than, and I travel around a lot, with what I do, either, going to different conferences and stuff. And I have to say that Los Angeles has the most, at least outwardly, collegiate trial scene. Now, inwardly, people may be rooting for each other or selfish, I don't know, but outwardly, it's a very collaborative group of people in Los Angeles, that's for sure. So you get to LA and you finally pass the bar, and talk to us a little bit about your journey from, getting that. That's probably in the mail back then when you found out about you passed the bar. Because I know it was in the mail for me initially, and so it had to be for the mail for you because you're a little older than me. But when you first passed the bar, tell us about your journey as a lawyer and eventually a trial lawyer.
Of course, I could have started practicing in Texas, but decided to come here instead and take this bar. And so what I did was, after I took the California bar, it was a few months before I would get my results. So I went to work as a law clerk at an insurance defense firm. And I was working there when I got that letter in the mail telling me I'd passed the bar. And they hired me on as a lawyer. So the first year and a half of my practice was actually as a defense lawyer. And I learned a lot about how the defense thinks and how insurance companies think and so forth before I decided to move to the plaintiff's side, which was always the bent that I had anyway, ever all the way back to when I was in college in the 60s. I was a big fan of Ralph Nader and everything that he was doing. I believed that a courtroom was a place where a small child could speak as loudly as General Motors in that venue. And it just interested me. And in fact, the only case I tried at the defense firm in that first year and a half was a little plaintiff's case. So I've never tried a defense case. I've always been a plaintiff lawyer, even though I started out as a defense lawyer.
What kind of, besides, that year and a half, you learned a little bit about how the defense thinks. What other benefits would you say you got from, being there, other than you probably hate billing hours? So you're like, since
Yeah,
they like that, can you imagine
that was
40
that
years of
was
that job?
huge. I always underbilled because I always felt I was taking too long to get done what needed to be done. And I just, with my background and everything, I just didn't want to bill too much. So, but I worked my tail off, and I would often go back to the office in the evening to follow up on some research I was doing. And if I was working, for example, on a demur, I would keep going. I wouldn't just stop at the issues involved in that particular case, but I would launch into other areas of research that sort of branched off from the demur that I was working on, because I wanted to get the broadest knowledge and understanding about what I was doing as I could. So lots of hours, no vacation time. And then I also learned about how to try a case. Took a lot of depositions. I remember one of my friends there said the way to learn how to try a case is to take 1,000 depositions. Well, I don't know if that's quite accurate, but still a lot of depositions in important cases. I saw a lot. I learned a lot that I was able to put to use at trial.
So after you are there for a year and a half, and then you said you joined a plaintiff's firm, tell us about that transition and that process.
It was an easy transition. It was a firm I wanted to go to. It was essentially brand new. It was only 2 or 3 years old. And the name of the firm was Voorhees, Greene, and O'Reilly. And the Greene is Brown Greene, who became my partner for all these many, many years after I became a plaintiff lawyer. And Charlie O'Reilly, after whom the Trial Lawyers Association Trial Lawyer of the Year Award is named. And Charlie was a brilliant trial lawyer. I learned a lot from him. So anyway, that's the firm that I went over and joined at its very earliest, and dealt with a lot of great lawyers in the firm. Brown, Charlie, Jerry Agnew was in that firm. Bruce Broillet came on, actually started out at the firm a couple of years after I started. A number of really good lawyers. In later years, Brian Panish came on, and he became a partner in our firm before he left the firm in order to form his own firm. Gary Paul, who is one of the great leaders of AAJ and has been for many years and does asbestos cases, he was one of our partners. So I just have had interactions with many wonderful lawyers over the years.
And so that firm that you joined is the same firm with a different name, of course, as where you're at today. So,
right, the firm is now Greene Broillet and Wheeler, and another tremendous lawyer that I've had dealings with in the firm, obviously for all these years, is Tim Wheeler. A lot of people know and love Tim. He's the kind of guy that it is sometimes said everybody wants to be on his team about a quarterback. Everybody wants to be on his team. That's the kind of guy Tim is. And he started out as a law clerk in the early 70s at the firm, about the time I came over as a lawyer, and been with us ever since as a partner.
all right. So let's talk about your philosophy on trial, and and in general, but also specifically in regards to a couple cases. one that you recently tried, I think you just got a verdict like 2 weeks ago. And then when you tried a little bit back, that is probably one of your more famous cases, only because of the plaintiff was a very famous person, the Erin Andrews case. So looking at the first, like the 90 days or so before you go to trial, tell us about some of your processes and things you're doing to get ready to, I guess, perform in the courtroom.
Yeah, so it really, Dan, it kind of starts on the first day of interviewing the client and deciding whether I'm going to take the case. From day one, I'm thinking about closing argument. How am I going to feel about getting up and making my point about this particular case? How am I going to formulate my arguments? How am I going to frame the evidence that I've got to the greatest advantage of my client? So it begins right at the beginning. And in terms of philosophy, I once heard it said, and I think it's so true, that a trial is nothing but a fight for credibility. So you need to be working on credibility from day one. And while your style, your way of presenting is certainly important to credibility, your facts and the way you organize them and the way you present them is also extremely important to credibility. But as I'm getting close to 90 days before trial, I am obviously thinking really focused based on all the evidence as to how I'm going to present that evidence, how I'm going to organize the witnesses, what the background and the themes are going to be, how this is all going to be framed for the jury. So at the 90-day mark, or, roughly a few months before, I'm thinking about all those things. We're in the midst of expert depots, pinning a lot of things down. That's what we're doing at that point.
All right. And you also, getting your motions in limine, your video clips, all of those kind of things are all getting put together.
Yeah, practically speaking, the practical things are putting together the paperwork for the court, the motions in limine, the oppositions to the defense motions, the witness list, the exhibit list, the possible jury questionnaire, depending on the judge, depending on the case, possibly a focus group at that point, although maybe further down the line after expert depots, and beginning to well, I look at virtually every depot in the case, and usually all of them, although sometimes some of the depots are not really pertinent given the way the case is going to trial at that point. But I'll read them myself. I will outline them myself. I will double underline them. I'm a big believer in preparation. And I think people ask me why I prepare so hard. And the answer is, I know there's always going to be surprises in the trial, no matter what you do. So the better prepared you are, the better you can react on the spot to deal with some surprise that comes up. The better you know your case, the better you can deal with adverse points that might come up. So all of those things, I'm doing all those things, looking at possibly doing a focus group at that point. And it's not just me. We have a team on each case. So we're collaborating, we're sharing ideas, we're bouncing ideas off of each other and our jury consultant, and the other lawyers in the office. It's a team effort in our law firm.
All right. So let's look at, in jurisdictions like California and some other states, we get a mini opening. So how do you, when you have the opportunity to do a mini opening, how do you approach it?
So, there are two possible concepts to a mini opening. One is looking at the rule of primacy, that you present your strongest possible case, because it's the first thing the jurors are hearing. The problem with that is that it can cause your best jurors to say that they can't be on the jury because they've already decided based on what they've heard. So the other approach, which we tend to use more often, is to highlight the weaknesses of your case. Not to talk only about that, but to highlight the problems with the case. And that way, you're more likely to have jurors who would favor the defense say that they can't be fair after hearing some of the issues that are going to come up in the case.
So with the mini opening, like you just recently tried a case up north in Yolo County, which isn't the
Right.
bastion of liberalness that we have maybe in Southern California. So Tell us a little bit about, that case and how you, since it was your most recent case, I figure it's your best effort as a trial lawyer yet. Maybe not be your biggest verdict, but everything you had as a trial lawyer went into that case. So I think it's a good example to talk about. And so the mini opening on that case, you know,
Well, on that point that you made, it has always been my philosophy that you're only as good as your next case, not as good as your last case. So that keeps you going. So, but on that particular case, what happened was my client was a 69-year-old truck driver, and he was pulling a 53-foot trailer, which he typically did. So he's got a tractor and the trailer behind him. And the doors on the back of the trailer open up like this. Okay, they swing. They don't roll up, they swing, and they're each 4 feet wide. So what had happened was my client had come to make a delivery to a place that he had delivered to before, to a warehouse. He pulls across the double yellow lines, goes against traffic, parks against traffic. Then he gets out of his truck, and after checking in, he goes to the back of the trailer parked against traffic. He opens up the doors and swings them out. So the passenger side door, which is against traffic on the back of the truck, swings out into traffic. And unfortunately, the security video from the company, because we sued the warehouse, the security video showed him doing that without first looking around the side to see if there was any traffic coming. So the door goes out into the lane of traffic, and right there immediately, and unable to avoid it, is a van that hits the door and swings it back at high speed to our guy and knocks him down to the ground. And so my client suffered a brain injury and various orthopedic injuries as a result of this. Couldn't work anymore. So that's the story. And, in doing focus groups, what we found was that the big thing that hung up the defense-minded jurors on the case, I should say the defense-leaning jurors on the case, the big thing that created a problem for him was that my guy had opened the doors without looking around the side first. It was bad enough that he was parked against traffic, but he opened the doors without looking. So that was a big part of my mini opening, really pounding the fact that he opened the doors without looking so that jurors who couldn't be fair would reveal themselves, having heard that fact, that they couldn't get past that. So that's an example of taking a fact that's going to hurt you, and while you talk a little bit about why you're there with your case, at the same time you emphasize the strongest defense position, and that will help you to identify jurors that are not good for your case.
and you also mentioned the amount of money you're going to be looking for in
Well,
that part of the trial.
yeah, the judge would not allow the amount of money, but the judge did allow us to talk about millions of dollars. And so in that case, we had various calculations of economic loss, and they were in the millions of dollars. So I, talked with them about that, and if they had a problem with that, if they had an issue or a concern about awarding that kind of money. But then I also went over to non-economic damages because those were there too. He had made a pretty good recovery, but still had significant deficits as a result of the brain injury and significant orthopedic problems. And so I was able to ask people, what is your reaction to hearing that I'll be asking you to award him millions of dollars for non-economic damages, for what we sometimes call the loss of the quality of life? How do you feel about that? So yes, I covered damages. I covered the liability picture. I also asked questions relating to people's feelings about lawsuits, tort reform questions. Years ago, I'm sorry, go ahead.
Oh, no, I could just say, so now, right, obviously this segues right into voir dire, which is what you're touching on now,
Yeah,
is, and that's what I was going to ask you, your approach to voir dire, and specifically in this case, and then and also to touch on the Erin Andrews case, because that's the trial you did a few years back in Nashville. I think it was like a negligent security, invasion of privacy type of tort that you're
right.
going to be talking about in Huntington Beach. So,
Yeah. Well, okay. So on the case I just tried, I think the way I was just phrasing questions as examples is important. I try to get the jurors to talk more than me during jury selection. I want to know how they see the world. I'm not trying to talk them into how I see the world. So that's why, for example, I was saying, I'll be recommending that you award millions of dollars for pain and suffering, and there won't be a bill that you can operate off of. You'll have to figure it out for yourself after listening to the evidence. How do you feel about that? And so that forces the potential juror to push a noun against a verb, create a sentence, maybe a paragraph, and a thought. How do you feel about that? And so I try, when I read my transcripts, I never really achieve this, but I try to get the jurors talking more than I am, if I possibly can. And that tells me something about them and how they see the world. So in Erin Andrews, in Erin Andrews, that case was in Nashville. And so voir dire was a little bit different down there, and there were no questionnaires, and voir dire was pretty quick. But what I will say is this: we've all heard of the concept that people talk about putting a number out there. In Nashville, in Tennessee, the law allows the defendant to send a request to the plaintiff to state the amount of damages they're seeking. Now, we do have a statement of damages here in California, but it has teeth in Tennessee, because in Tennessee, where the Erin Andrews case was tried, the defense can use that number that you have given as to what you're asking for. And if you ask for too little and get a verdict larger than what you've asked for, it gets cut down to that number. So you've got to have a number that's high enough, but also a number that's not going to look ridiculous. So the number we put down was $75 million. The verdict ended up being 55. But what happened was, in jury selection in that case, the defense, when they got up to ask questions, decided to announce that Ms. Andrews is suing for $75 million. Did you all know that? And nobody did, but there was no negative reaction to it. So what they did was they put a number out there, the defense did, a big number, that had the jury already primed for what I was going to ask for 2 or 3 weeks later in closing argument.
So that's another example of defense adding value to the plaintiff's case.
Yeah. And they thought what they were going to be doing, and it was understandable, they were very good lawyers, was they were going to turn the jury against, a Nashville jury against her because she was seeking $75 million, and it got interpreted a completely different way by the jury.
On that particular case, the Erin Andrews case, what were some of the key issues of voir dire that you had to, I guess, take on? I mean, because I think, generally in voir dire, I assume like topics like money or sympathy or things like that, you probably have set pieces that you do some rendition of them or another in every case.
Yeah, well, in the Andrews case, as I said, the jury selection process in Tennessee is really much faster than it is here. And my co-counsel, my wonderful co-counsel, a lawyer named Randy Kennard in Nashville, the best lawyer in Tennessee, Randy did the jury selection. And so what he did was, because he knew what the Nashville people and potential jurors were like, that's where he tries cases. So he did jury selection, and we pretty much split the witnesses up, and then I did the closing argument and the rebuttal. But he got the plane off the ground, so to speak. And the way he started was on the issue of common sense. And he went up and he wrote on the board the words common sense. And he turned to the jurors and said, we all agree, basically, that you shouldn't leave your common sense at the courthouse door when you're evaluating this evidence. It was those kinds of general concepts that he talked about, because, as I said, jury selection there is much different than it is here.
All right. And then with the common sense writing on the board, what was his, I guess, what was,
Yeah,
I mean,
what he
because
was
common sense
doing.
is such a general, obvious thing that it's like,
Yeah. But the concepts of common sense in a trial, sympathy, and how we don't want sympathy. We've had enough sympathy. Getting those points out there, we're gaining credibility with the jurors right up front. So jury selection there is so limited that getting some of those points out there and dispelling some of the notions that jurors walk into the courtroom with is an important thing. And we ended up getting an excellent jury, obviously.
but the case you just tried up in Yolo County with the driver of the vehicle, the truck that, that was a comparative fault case, which you knew going in that your client was going to take a decent chunk of responsibility on that. So did you voir dire on the comparative fault aspect of it?
Oh, for sure. In fact, right from the get-go, I think even in my mini opening, but certainly during my voir dire of the witness of the jury, potential jurors, I acknowledged right up front that that my client was going to accept responsibility for his share of the fault of what had happened here. He accepts that he did something wrong, but we're also saying that they did something wrong. And it'll be your job to decide on what those percentages are. And all through the case, one of the themes of the case was our guy is accountable for his own actions and he accepts accountability, but they won't. And so all through, and what happens is when you do something like that, how when a defendant admits liability, that it sort of takes the wind out of your sails. And, it's like they're being reasonable. You must be asking for too much money, all of those things, which I don't buy, but that's why the defense is doing it. In this case, by my admitting right up front the obvious fact, because he didn't look, he opened the door without looking. What was I going to say about that? Admitting the obvious fact that this experienced truck driver had made a human error, had made a mistake, and is accepting responsibility for it, that shifted all the focus over on the defendant and its warehouse, which is what the case was about.
All right. Now the opening statement. So what's your, moving to, from voir dire to opening statement, what's your approach to the opening?
Okay, so an opening statement has to take the evidence that you have and organize it in a way that it is most appealing to your client's side of the case. So let me give you an example from that trial. You're probably wondering why we sued the warehouse, because after all, our guy parked on the opposite side of the street against traffic and then opens the doors. And what are you doing suing the warehouse about that? So the key to that was that when I deposed the executive vice president of the company, which is the largest beverage manufacturing company west of the Mississippi, so it's a big company. When I deposed him, he admitted that the warehouse was not originally designed to accept 53-foot trailers. So the reason was that this warehouse was built close to the road. So in a typical warehouse, there'd be a lot of blacktop around the loading dock so that the driver can back in without being on the road. But because they were using 53 or allowing the receipt of 53-foot trailers at this warehouse, a lot of the activities that the drivers did had to be on the road. And one of those activities that had to be on the road was opening and closing the doors on the back of the trailer because there wasn't enough room to do it once you got in. So what we were talking about was, and one of the first concepts I explained to the jury was this case involves a company who was trying to fit a square peg into a round hole. They were using the wrong tool for the job. And right from the get-go, I'm talking about the admission that they made that this was never designed for these kinds of trailers. And then my argument was that forced people to be opening and closing doors on the road. before they backed in. So my opening was built around that concept and around the principle of design, that whatever is designed, whether it's a product, a highway, a warehouse, a procedure at a warehouse, any design should be such as to minimize the consequence of human error. You can see that in your own car with all the safety devices in your own car. It's designed to minimize the consequence of human error. What happened here, I was telling the jury, was that this was designed to maximize the adverse consequences of a human error, and we see it right here in this case. So that's how my opening statement was designed to flow, so that it made sense why we were suing the company and its warehouse for what happened here, for its share of the fault.
I want to ask you about your like visual strategy in opening. Do you use a lot of PowerPoints, foam cool boards, document cameras, physical models? What kind of things do you kind of gravitate towards as far as showing the story as opposed to just, speaking?
Sure. Any and all of the above. So I will often have PowerPoint, but I don't rely on the PowerPoint. I don't just read the PowerPoint. I often say to the jury when I use them almost as putting up exhibits. It's almost like putting up the old foam core boards that we used to use for enlargements. And I'll often find myself, I'll put one up and the jurors look at it and I'll say, wait a minute, give me your eyes back, look at me, let me talk to you first, and then I'll explain what you're looking at up there. So yes, I use PowerPoint, but I don't let it overwhelm me or get in my way. In this particular case, Dan, I did something based on a case I tried in 1986. The case in 1986 involved the design of a water heater and burn injuries. And I had a model made of the water heater, of a water heater, an exemplar, on a platform that could roll around. And I had it sitting there in front of the jury in my opening statement. And then witness after witness, and all the way through closing argument. And I began to realize that what was going on was the jury was looking at the water heater, and the focus was on the water heater instead of the conduct of the person that had gotten harmed. The defense always likes to try the conduct in products cases, and we're trying the product design. Well, there was the water heater the whole time, keeping the focus on the right place for the jury. And it was almost like the water heater was in the dock, like in the old, cases in Great Britain where the defendant would stand there in the dock the whole time. And there was the water heater in the dock. And I got a nice verdict on the case. So what I did in this case about the warehouse was, they wanted to make the whole case, as they started their opening statement, this case is very simple. He opened the door without looking, and he should have, and he knew he should have, and he admits it, he should have. They wanted it to be about the conduct. For me, it was about the design and the setup of this warehouse. So we had two big old-fashioned blow-ups made, aerial views of the warehouse from a couple of different directions. And we put those up on easels at each end of the jury box. And they stayed there the whole trial. And so we were focusing the jury where we thought the focus should be, which was on the warehouse and the way it was used. And we ended up getting a nice verdict on it.
Your opening statement, do you practice it at all before you give it?
No. I will give myself sort of a word outline. I don't write things out. I know by the time I get to doing that opening statement and preparing for it, I know my case inside out. And so I know right where I'm going with it. And so what I will do is I'll create myself a little word outline highlighting points I'm going to make. I might do them in the margin of my printout of the PowerPoint so that I, make sure I'm tying a particular point to a particular slide. But then those things move around during the opening statement because it's very much in the moment. I'm watching how the jurors are reacting. So that's the sort of thing I do for my opening statement, for my closing argument. I'm not writing things out, and I'm definitely not practicing things ahead of time.
All right. Well, we would encourage people to practice here at Travelers University. So you're being a bad role model for everybody. As long
Well,
as you can do
okay.
this after, 49 years, you can.
All right. So, Dan, let me address that. Practice is incredibly important, but let me tell you where my practice happened. Remember, I told you in high school I was very active in speech and debate. And so, what I would do is back then, I would write out my speeches if I was giving a speech as opposed to being in a debate. And I would sit or stand in the bathroom at my house where I grew up, and I would present to myself in the mirror in the bathroom. I would go over and over again, watching how I presented, how I was communicating, almost like having a videotape, which we didn't have back then, to see how I was doing. Okay. So I've practiced a lot, but it's all, it's because I've tried so many cases, a lot of it becomes second nature. And I know where I'm going with my case. So yeah, but do practice. For other lawyers out there, it's okay to practice. I don't mean to be a bad role model.
Well, at least for the first 30 years of our careers, we can keep practicing. After 30, maybe we don't practice quite as much. Like, most, I think that's more common amongst our, people have been doing it a while. They got their PowerPoints or their visuals and kind of just are running through it in their mind constantly.
Yeah.
They're practicing in their heads, like, in the Matrix where you visualize this himself doing it.
Yep.
Let's talk about proving your case and witness sequencing and order of proof. How do you think about that?
Oh, critical. The sequence of witnesses, the timing of witnesses. So I think I mentioned about the vice president, executive vice president company that acknowledged what he did, that it was a warehouse that was not designed for 53-foot trailers. So he was the first witness in the case because I wanted to hang a lantern on the fact that what I just told the jurors in opening statement, we're hearing it right here from the very first witness. And so the first group of witnesses are, proving for my client that this was the wrong way to do this, the way the company did it, and that he was stuck having to open his doors on the roadway parked against traffic. Okay. So at that, you asked about the 90-day mark. I mean, it's not a particular mark for me, it's as I'm getting ready, I'm thinking about things and all. And one of the things that's critically important is the order of witnesses. So to me, in this case, it jumped out at me that the first witness should be this executive vice president of the company. There's also something else in the organization of witnesses, and that is timing. And let me go back to the Erin Andrews case for a moment. In that case, one of the things that I had done is we hired an expert in the internet from Penn State University, to us, the #1 guy in the country. And we asked him to analyze how many times the video of Erin Andrews naked on the internet had been viewed in the first 7 years since the case had started. And he came up with a number of, I believe it was 16.7 or 16.9 million times. Now, I don't want to get ahead of ourselves here, but at the Trial Lawyers University thing in Huntington Beach, I'm going to explain how I use that number in the trial. There's a lot of really interesting stuff, I think, that I'm going to explain about how we got that verdict, how we held the hotel responsible for what the criminal did, and then how we got the damages. So, but putting that aside, that $16.9 million number, 16.9 million views in the first 7 years was really important. We also showed that even 7 years later, at the time of the trial, it was being viewed 300 to 500,000 times a year. So you can imagine what the future would hold for her. And that was a very conservative number because it was assuming that only one person was watching and they only watched it once. So it's probably a much bigger number than that. So anyway, with that witness, I decided that that's when we would show the video, the 4.5 minute video of her naked in her hotel room. A very innocent person in there had no idea she was being videotaped. And I knew it would be very powerful with the jury. So you combined the numbers with the video, and it really brought home the magnitude of this. Anyway, in the middle of trial, there was a 3-day weekend. So we timed things so that I would put him on the stand just before the 3-day weekend that afternoon. And we would show the videos and talk about the numbers and talk about how it cannot be gotten off the internet. It's going to be there forever. And we had all that information packed into the afternoon before the 3-day weekend and sent the jurors home for the 3-day weekend with that information. So you want to time things. You want to organize the witnesses as best you can to tell your story persuasively. And then you want to time things to leave them at the end of the day with something strong and Friday of a weekend with something strong, or of a 3-day weekend. So that was a long response, but that's what I'm thinking about.
Got it. How about your plaintiff? Where do you like to have your plaintiff when it's their turn to get up there, come in?
Really varies, but typically deep in the case. In the brain damage case up north in Yolo County, it was fairly late in the case because, he was able to get up and testify and walk and talk and everything. And you might not know that there's anything wrong if you hadn't seen the brain scans that showed a lot of bleeding that happened, if you hadn't heard from the neuropsychologists, if you hadn't heard from the people from the Center for Neuroskills, where he went through rehabilitation for a couple of years, who, by the way, explained that he gave maximum effort all the time to be as good as he could be. And so if they don't know all that ahead of time, they might look at him and say, well, he doesn't look all that bad to me. He's talking and walking and testifying. But if they hear all that background, then they're more sensitive to the stuff that they're seeing when he loses his train of thought or something like that. And so that had to come at a certain point in the case when they'd heard plenty of medical testimony.
How about redirect? What's your viewpoint on redirect?
Well, I don't like a lot of redirect. Sometimes you have to do it. But, the more redirect you do, the more you can look like you've been hurt by the cross. Also, the more subjects you cover on redirect, the more opportunity you're giving to the defense to say, well, Your Honor, we should be able to ask about this because they asked about this on redirect. So the narrower you can make it, the better. At the same time, you do have to deal with the things that you were hurt by on the cross-examination, obviously. So there's a lot of judgment. Look, there's a lot of judgment that comes into all of this. There are no absolute rules. It's about the trial is a fight for credibility. And there's a lot of different ways to get there, and it varies from case to case.
That's why it takes a lot of trials and a lot of practice to get all that judgment that you need. That's why, I'm pretty fortunate to sat kind of in this chair, and when this chair, a chair similar to it, for the last 3 years to interview the best trial lawyers in the country on just these topics. So I appreciate you coaching me and mentoring me here during our podcast, Bruce. It's a lot to be learned.
More than happy to say what I've learned. Apropos of what you were saying about doing it a lot, the more you try cases, and this is why it's important that people watching say to themselves, I really have to get out there and try cases. Of course, your client's interest comes first. So if they offer you enough money, you can't just go try the case to try the case. But don't be afraid to try a difficult case if they're not going to be serious. So what I tell the people in our office is, the more pitches you see in trial, the more second nature some things become. And the more second nature things become about how to do this and how to do that and what should I do here and everything, the more your bandwidth, such as it is, can be used to go into more creative areas and to see things that you might not have seen in your first few trials and to understand things. I can give you an example from the Erin Andrews case. Okay, so remember that the Andrews case had to do with her being videotaped naked and being put on the internet by this criminal, and the violation of her privacy, the embarrassment, the humiliation, all of that. So the news media covered it extensively, and the judge had decided at the beginning of the case that only one camera, video camera, could be in the courtroom, and everybody else, all the other networks, would have to operate off that feed. So, but he said, every time, I don't want the camera ever to be trained on the jurors. I want it to be trained on the witness. And whenever the jurors are coming in, the camera has to be pointed at the wall or something like that. So I've given my closing argument. The defense has given their closing argument. And I'm standing there while the jurors who have taken a break are filing back into the courtroom. And trial lawyers don't have a lot of original ideas. A lot of our ideas come from other great trial lawyers that we've been to their seminars or read their transcripts or whatever and gotten great ideas. So many of my ideas are from other people or hybrids of what other people said and everything. But I'm standing there watching the jury file back in for rebuttal. And Dan, I had an original thought. I'm standing there, I'm going, my gosh, I'm having an original thought. So I'm watching them file back in, and then I get up to give my rebuttal. And during my rebuttal, at some point I said, ladies and gentlemen, have you all noticed that every time you come into the courtroom, that the camera is pointed away from you? And then every time you leave the courtroom, the camera is pointed away from you. And the only place that the camera can go is to the witness stand to show the witness. Do you know why? To protect your privacy. That's what the case was about, protecting privacy. And you could see the jurors kind of sit back and look, and, it's almost like they became part of the story because their privacy was being protected here, but hers was not. And of course, a big difference is that the jurors, as some of them did, could go on TV afterwards or give interviews because they chose to. But if they chose not to, they could just go home and their privacy was protected. She had no choice, Dan. So I had an original thought, and I'll probably never have another case where I can use that argument.
Probably not. Those original thoughts, they only happen when your mind is relaxed.
That's
my
my
point. Be
point.
creative.
Yeah, that's my point. If I had been sitting there, hadn't seen a lot of pitches and was going, now, should I do this in rebuttal? And what should I do? I knew what I was going to do in rebuttal. I already knew it, which freed up my bandwidth, to the extent there is one, to feel what else was going on in the courtroom and to see things I would not otherwise have seen. Experience, pitches, trying cases.
Right. That's what Rex Parris often talks about, bandwidth, and doing everything we can to maintain our bandwidth and burn up the defense's bandwidth to wear them down. Even if it's having your associates file briefs that may not have the deepest teeth, but it forces the defense to think about it and distract them and all those things, all those tactics of trial strategy that people at the top do, because everything matters in a courtroom. There's no doubt about that. Well, moving on to cross-examination. And, in this case, you had some witnesses you have to cross up north that were trying to prevent you from getting what you believed was justice. So when you approach, the cross, how do you go about approaching it?
Yeah, it's different again from witness to witness, but I can give you a couple of examples from that case. One of the people they put on the witness stand during their case was their director of safety. And I had looked him, we had his deposition, but afterwards I had looked him up because he mentioned that he was getting a master's at Pennsylvania University of Indiana, something like that. And so I looked up to just see what his coursework might have been, to see whether part of his coursework was human factors and design, that sort of thing. It told me enough that I was able to ask him a question on cross that I used. It was the very last thing I put up at the end of rebuttal from the transcript. I asked him, go something like this: isn't it true that the rule of design requires the design of whatever it is, whether it's a product or a warehouse, the design must be such as to minimize the consequences of human error? And he said yes, which fell right in line with what my expert from the University of Cincinnati had said about the design principles. It was, going back to the beginning of my opening statement, it was the theme of the case from the beginning. It should minimize human error, not exacerbate it and maximize it. So that's one example. Another one, sometimes I would just ask a question of one of their experts that I didn't really care what the answer was. And you know, don't you, Mr. Expert, that the executive vice president of the company admitted under oath to this jury that that warehouse was never designed to receive 53-foot trailers. You know that, don't you? I don't care what the answer is, because if he says no, he's totally unprepared. He didn't know that. And if he says yes, what does he do with it? So yeah, different approaches. You know, they put on an expert trucking guy, right? So the trucking guy gets up there and says, oh, it's not so hard to back into this facility. You know, I've been driving trucks for years and, you know, I could have done it and everything. But they didn't bring out what I brought out on cross. So I said, when you went out there to the site to look at the warehouse, you were there with the lawyer for the company, right? He said, yes. And you told the lawyer for the company, oh, this can be backed into. And you just demonstrated that to him in your van. You'll agree with me that backing into a warehouse in a van is a little different than backing in with a tractor and a 53-foot trailer. Now, won't you? And he fought me on that. And so then I asked him, well, did you turn to the lawyer there and say, can I use one of the defendant's own tractor trailers, 53-foot trailers that were right there at the site, and demonstrate this for the jury? Did you suggest that to him? And he said no. And then I dropped in the little question, how much are they paying you to be here? Now, I have a philosophy on the thing about money that experts charge. You know, make it meaningful. Get to a point on your cross-examination where it sounds like the expert is saying something that doesn't really make sense. Like, you know, the sun rises in the south. Something that doesn't make sense that the jurors intuitively know is wrong, and then drop in there, how much are you charging them for being here today? And the jurors roll their eyes and totally rejected what the guy had to say. So it's different from witness to witness on cross-examination.
All right. And speaking of, so after cross, and finally we get to closing argument. And, you know, I know that the case that you just tried was a tough case of comparative fault. And, you know, but when it comes to closing, I think you start thinking about your closing when you're interviewing the plaintiff.
Right from the beginning, but I don't put blinders on. I pay attention to the evidence. You know, my good friend Larry Feldman, who was a great trial lawyer here in LA, he and I were getting ready to speak at a seminar in San Diego, and he said, you know, the case never looks as good as it did on day one. You know, all kinds of problems develop that you have to deal with. Now, that's not always true. Sometimes the case gets better. Okay. But you've got to be aware of what's going on in the case, aware of your evidence, and where do you need to give ground and where do you need to shore things up? What are the weak links in your chain? So I'm not finalizing what I'm going to say in closing argument until we're just about there. And I even may make adjustments right in the middle of closing argument with the jury.
So in the case that you just tried up in Yolo County, that closing argument, what was your, approach to that and the sequencing in your mind and stuff so that you could get your minimum fault and maximum verdict?
Yeah, the percentage is
Minimum
what
percentage.
we're talking about. I mean, that was the big battle on liability. I think in the end, once all the evidence was in, was, what percentage are we going to put on the company? So what I did was, going back to that theme of the design should be such as to minimize the consequence of human error, I put a screen up, on the PowerPoint that had a line down the middle. And on one side was the name of my client, and under that were the words human error, a mistake, a momentary mistake in a 44-year career. Human error. Then on the other side, I started listing all the failures by the company that owned and ran the warehouse, starting with using a building that was not designed for 53-foot trailers. And then from there, going one after another, we had a lot of evidence of a poor signing with regard to parking on the road that they had done. We had another one about the failure to have any written policies and procedures. Another one about essentially the absence of training on this subject of how to park these trucks by the warehouse dock people, one after another. There were 10 or 11, 12, I forget the number, of all of these failures by the company. And so what I said to the jury was, it's tempting to just split it 50-50. But comparative fault does not mean split the baby. It says comparative, which comes from the word compare. And you have to compare in your job as jurors, you have to compare the quality and extent of one person's fault with the quality and extent of the other. So every one of these decisions, almost to the particular decision right down the line, were made at the corporate and management level and were thought out, and those failures were not just a momentary mistake. They were decisions that were made that put this man in danger. On the other side, this man made a momentary mistake. So when you compare those two, I believe you find that the company has a much bigger responsibility than the man who made the human mistake. That's how I did comparative.
How'd you talk about the money in that case?
The money, well, let me just come back and say, I asked the jury for 75%, 25%, 75% against the company and 25% against my guy. The other side said complete defense or 10% against the company if they have to do something, and 90% against my guy. The jury decided 70% against the company and 30% against my guy.
How'd you feel about that?
Extremely happy. I mean, so many people told us we could not win this case. And, my partner, Ivan Puchal, was with me on the case, and he did a great job on the case. And one of our new lawyers, Francisco Yeverino, was also on the case. We were all overjoyed because people told us going in there, you can't win that case, and especially not in Yolo County.
Well, not if you don't try.
If you don't let go of the side of the pool, you'll never get to the other side.
Truer words were never spoken.
Boy, and the young lawyers that are listening to us, there's that temptation when the pressure's on and you're going to go down there and they're going to call up a jury and everything to somehow settle the case. You can always figure out a justification for settling the case. But, if you never leave first base, you never get to second. So if your client deserves a trial, give them the best trial that you can.
Yeah. How about, okay, so, but money and YOLO, because
Yeah,
they're not exactly generous up in these parts from
yeah.
what I hear. So how did you go about talking about it and addressing it for your client in this case?
Well, I got lucky to get a pretty good jury. Um, Obviously, I'm saying that now, but I felt that at jury selection and all the way through, they were very engaged with the case, very interested. Uh, we started with 16 jurors, and at the end of 3 weeks, all 16 were still there, including the 4 alternates.
Wow.
One of the alternates, his mother had a stroke during the trial, and he came in and said, I might have to leave or make phone calls or something. She's in the hospital. She's doing much better. But he didn't want to leave the jury. So I knew that they were really engaged. One of the things the judge did is after every witness, he let the jurors write down a question they would have for the witness. And we were getting floods of great questions from the jurors. And so anyway, I had a pretty good feeling that the jury was going to be with us. So the mainstay was the economic losses. So the life care plan, along with the past medical and so on, was in a little bit of lost earnings, although he was, 72 at the time of trial. The total was 5 million plus of economic losses. And so when you got economic losses like that and a really good plaintiff who made a very good witness and a wonderful spouse of his who she's just a doll, and she made a wonderful witness, and a family friend who came in and just did a great job of explaining the differences in my client from before and after this happened. I was comfortable in putting up millions of dollars. Obviously, the jury, came back with a damage award on the non-economic side that matched the economic side. So the total verdict was 11.2 million. And then, of course, there was the reduction of 30% comparative fault. But we were extremely pleased with the result on that case.
As far as the damage number, like the non-economic, how did you really think about going to ask about that? Because I know like a lot of people these days use big data, either from like John Campbell or the Campbell, somebody like that. What did you do to try to figure out what you thought was the appropriate amount of compensation for, because he had a TBI and some orthopedic injuries, correct?
Yeah, yeah,
So for
yeah. So you know, if you, what I try to do is find some kind of metric. I don't like to just throw a number out there that has no basis anywhere of any kind of thought. So, a metric that I will frequently use is, and I think a lot of people do, is life expectancy. So, you've got a work life expectancy talking about earnings, but you've got a life expectancy talking about how long the person is expected to live given the injury and so on. And so I'm trying to remember the specific number I used per year, and might have been $1 million per year. Just trying to remember right now. But I put a number in there that then gets multiplied. And, some of it has to do with the amount of past medical and whether that becomes a basis for picking a number to put into the metric. But the idea is to give the jury something. Look, I've got to feel comfortable asking for a lot of money. And, I went to Catholic schools and I was always out selling chocolate and raffle tickets to try to make money for the high school. So I'm used to asking for money, but still, if I'm going to ask for a lot of money, I want the jury to know that I reasoned my way through this. So I'll often use life expectancy and a per diem. In another case, where I was suing on behalf of a 75-year-old woman for the death of her 48-year-old single son, The last day of trial, I had a really good cross-examination of the defense, one of the defense experts, really good. And the jurors just, just were almost sneering at him as he left the witness box. And he was $600 an hour. So I used that in closing. And I said, if they can afford to pay that guy $600 an hour, then clearly they can afford to pay for the death of this man. I forget if I used 600 an hour, 300 an hour, 600 a day, whatever it was. And the verdict ended up all non-economic damages, no economic damages at all. And the verdict was $15 million for non-economic damages. So I'm always looking for a metric. I did it in the Erin Andrews case. I'll explain that at the Trial Lawyers University event in Huntington Beach, how I did that.
Give us a teaser, Bruce. I mean, not
Well,
everybody's going to make it there, and if they can't, there's a way to watch it anyways. But because this
yeah,
one is $55 million for this brief invasion and all this stuff, and
yeah. So, well, first of all, it wasn't brief. It's something that people are looking at every day. And she would get taunted at football games when she was doing the sideline reporting. Guys yelling out, "I've seen you naked. I know how you comb your hair naked," and all that kind of stuff. She was putting up with that all the time, and she will for the rest of her life. And so I said to the jurors, she is living her dream. She's living her dream. This was what she always wanted to do. But at the same time, she's living a nightmare, hand in hand. And I respect her for staying in the public eye because she knows the more she's in the public eye, the more people are going to be going and looking at her naked on the internet. So I said, you heard the testimony that already this has been viewed 16.9 million times. And you know that it's still being viewed 300 to 500,000 times a year, 7 years later. So I just asked myself, supposing for each one of those views, you were to award her just $1, you're already at $16.9 million. And then what about the future? All the times that her privacy will be invaded on the internet because of what happened at the Nashville Marriott Hotel. The day, that she has to decide whether she's going to tell her child what had happened because her child, who hasn't been born yet, she's now had a child, by the way, but when does she sit down and tell her child what had happened? Or does she just hope that nobody at school ever mentions it to her child and that she doesn't come home one day and say, "Mommy, I want to ask you about something"? She will be living with this every day for the rest of her life. And if you award her just $1 for each of those invasions, that should be your verdict. So I had a metric. I didn't just throw a number out there.
got it. Speaking
And
of,
by the way, Dan, when we made the decision of how much we would put down on that request for damages, and we made the decision to put down 75 million, even though we knew that they might try to use it against us, that's what I was thinking. I already knew what the numbers were going to be from the expert, and I knew how I was going to argue it. And that's why I said, we've got to make it high enough that it will cover whatever verdict we get.
makes a lot of sense because you didn't want to get a haircut. But speaking of the Erin Andrews trial, that case, I know you've tried a lot of big cases in your career, but that one's probably way up there as far as most known.
Well, it got a lot of publicity internationally. It resulted in a change in the conduct of hotels. You can't you shouldn't be able to call anybody at a hotel, the front desk and say, is so-and-so going to be there? You don't do that. And if you do tell them, you got to tell the person that they're asking about. But you shouldn't, what you should say if you're the hotel is, I'm sorry, I can't tell you that. If you know that person, why don't you call and ask that person? It was just outrageous that the hotel told this guy when he asked about it that she's going to be staying there, and then set him up at his request in the room next to her.
Was there a punitive damages component to this case?
No, because the guy who did it was in jail, and he was on the verdict form, but he was not at the trial. The emphasis of the case was against the hotel for their procedures and their failures.
Okay, just that their failures were so egregious that, I mean, they're almost intentional. I mean, given her name and room number to some stranger, that's craziness. I mean, if you think about today's world, that's crazy.
It's just, all I can tell you is was an extremely interesting case. And whoever comes to the Trial Lawyer University thing in Huntington Beach and sees this, they're going to see a lot of what this case was about and how interesting it was.
Well, and speaking about that, you're going to be speaking on this trial on June 6th. That's a Thursday. And we've given you 3 hours to talk about it. And you'll be speaking with one of your partners, Molly McBean.
Molly McKibben.
I'm sorry. See?
Yep.
And I haven't met Molly yet, so I'll be better with her name when I do meet her. So in those 3 hours, kind of give us a little snapshot of the different nuggets and trial lessons and stuff that you'll be covering.
Sure. In the first hour, we're going to be talking about the beginning of the case, how it was discovered that it was the Nashville Marriott, which is a very interesting story of its own, because it just looked like the inside of a hotel room on the internet. How we structured the complaint, the decision to sue both the Marriott and the guy who did the videoing and putting it on the internet. We're going to be talking about how we handled publicity issues, a whole bunch of the preliminary stuff. It really instructive on how to handle a case, not just like this, but any case that might get some publicity. Also, the decisions with regard to the verdict form, which were very important, as you'll hear at the seminar. The second hour is going to involve a lot of the discovery, what we found out in discovery, and then the trial itself, and what the frames and the themes were at the trial, and how we developed those things to maximize the case against the hotel. And then the third hour will be the closing argument, and we'll deconstruct the whole closing argument, how we put it together, what we said, why we said it, what the reasoning was, and it's like the culmination of the whole thing.
All right. And so for everybody who doesn't know, the website for the Huntington Beach Conference is tlubeach.com. It's going to be June 5th through 8th. June 2nd through 4th, we're doing a 3-day boot camp before the conference. Not only is it going to be super learning with great trial lawyers like Bruce Broillet, but there's also going to be super fun, because every night we have theme parties. And I know Bruce is only able to be there on Thursday, so he requested that we do a Ken and Barbie pink and white theme party for Thursday, because Bruce said that was his best Halloween costume from last year, and he wanted to be able to get it out of the mothballs and use it for a second run. He's already dialed in, doesn't have to go out shopping. But anyways, I'm really stoked for that conference. It's going to have 4 lecture tracks and 8 workshop tracks with people of the same caliber as Bruce Broillet teaching. Some of them you may not have heard of, though, because they didn't have famous cases like Bruce's, but they're great trial lawyers coming in from around the country, like Sean Claggett out of Vegas. Who else is there coming there? Lots of people. John Romano from Florida. Other inner circle friends of yours like Dale Gallipo and Lloyd Bell is teaching a med-mal masterclass. Dale's teaching a civil rights masterclass. That's 2 days with Dale Gallipo. 2 Days with Lloyd Bell. David D. Robertus, who's really dialed it in on employment law. He's teaching 2 days on employment. So we got, and then there's, the 4. So besides the 4 lecture tracks, there's also these different workshops other than master classes where you're going to you can get up on your feet and practice voir dire. Steve Vardazarian and Chris Dolan are both teaching different workshops on jury selection. So you got some really great lawyers teaching both the lectures and the workshops. And I'm excited. This is Bruce's debut at Trial Lawyers University. He said that we finally got it up to a caliber that he thinks is appropriate for him. And if we do a really, really good job, he'll consider coming out to Vegas, which is October 16th through 19th. And, if you're not able to make our live events, everything we do, have done, and ever will do is all been recorded, both webinars and live conferences. And they are located on a website, tluondemand.com, which is also an app for your phone. And we gather the pleadings, transcripts, and PowerPoints for all these cases. So you actually have like a library for trial. And let's see, Bruce, if people want to get a hold of you to ask you any questions and stuff, what's the best way to do that?
Well, my office number is 310-576-1200. My email address is bbroillet. That's BBROILLET at G as in Greene, B as in Broillet, W as in Wheeler, .law, LAW.
GBW.
.law.
.law. All right. And if anybody needs to get a hold of me for anything, my email, of course, is Dan at Trial Lawyers University. And since I don't have an office phone, I only have my cell phone. So that's 248-808-3130. All right, Bruce, thanks for stopping by today. I look forward to seeing you in about 4 weeks in Huntington Beach in person. And it's going to be awesome.
Pleasure.
I think you'll feel the same way at
Good.
the end of June 6th. Thanks. Take care.
Thank you. Thanks,
Bye,
Dan.
Bruce.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.